Good morning, everybody. We're just going to wait for a minute or two for everyone to get popped on.
Okay, I'm back.
Okay. Okay, we've got quite a few people on and it's 9 o'clock, so we're going to get the party started. Thanks for joining us, everybody. I'm Jody Greiner with Premier Wealth Management. Today, we have True Choice Financial Group, and they are going to be discussing wills, trust, and estate strategies. Our presenter today is going to be Alan Roman, and he's an attorney from the Detroit College of Law, so he knows what he's talking about. He's going to be doing the presentation today. His role at True Choice is he's the director of advanced strategies. Also with us today is Chris DeMars. He's with True Choice also. He's the vice president, advanced annuity sales. And also he's going to be at the annual meeting next week. So you'll get a chance to meet him in person, but he's on the call today as well. And in addition, we have Eric Loiza, and he is a senior director of business development through strategic partnerships. That's a big title you got, Eric. He's on the call with us today as well. And he is also going to be at the annual meeting next week as well. So you can meet him there. So those are the three people that we've got presenting this morning. And Alan, I'm going to let you take it away.
Thank you. Can you hear me clearly?
Yes.
All right. Well, I want to thank everybody for tuning in this morning. I am Alan Roman. Make sure you've got something to write with, because I'm going to give you some contact information here in 1 minute. But also, as I'm working through the slides, in particular, the second half of the slides, there's some things that are really important for you to not only note, but also engage in conversations with clients, especially higher net worth clients. And I'll kind of define that as we go through this, but it's my pleasure to be here. My contact information is as follows. So I'm going to give you my email address and my cell phone number, my real cell phone number. So email address is aroman, AROMAN, at True, TRU. There's no E on our True. So aroman at truechoicefinancial.com. aroman at truechoicefinancial.com. My cell phone number, this is my real cell phone number, 561 402 0315. 561 402 0315. Not sure how many, if any of you were at the Cambridge Ignite conference, but I spoke last week on a different subject than I'm going to speak on today. It was top 10 tax traps. This is something maybe we can move forward to closer to the end of the year with Premier. But the importance of estate planning, it's kind of generic. It really applies at any time to your high net worth clients. At this point, I kind of define a high net worth client with $5 million in net worth or above. There are some dramatic changes that may take place, could be as early as 2025. So I'll kind of highlight that as I go through, but keep in touch. There's no real rules of engagement. If you have a client or you have a scenario that you want to talk about, just call me. You've got the contact information, or email me. We can walk through some strategies, get the fact pattern straight. If you and I have a conversation and it does make sense, at a later time, we can get the client on the phone as part of my rules of engagement. As long as you and I speak, then you and I can, at some point after that conversation, have a client conversation. And I don't tell the client what to do. I just give them some guidance. My tagline is, because you work with your financial professional, you get my guidance for free, but I will not be your attorney. And hopefully all of you who are listening in, you have some semblance, or you have some contacts with an attorney, so that your client doesn't go to some third-party attorney and they refer them somewhere else. So before we begin, I've got an overall agenda. What we're going to talk about today starts with the very basic estate plan, and this encompasses probably half of the questions I get on estate planning. Is just the very basics. I literally had a situation last week when I was at Cambridge that I had to kind of leave the room to fix. It was a power of attorney situation. But basic estate plan we'll talk about. Then I'll move forward into the federal estate and gift taxation. I'm going to talk a little bit about some frequently used trusts, which are, I say, about almost half the questions we get. Number 4, I'm going to pass on that one right now. I'll talk about that one when I get there. But for all of you, the basic estate plan, and this involves wills, but it's not just wills. It's also general understanding of what a basic estate plan is. So, number 1, a will. Each state has their own set of laws for what a will is required to have for it to be a legitimate will in that state. There's witnessing, signatures. Some states even have notary requirements. A holographic will is also available in most states. So I'm going to define what a holographic will is by giving you an example. I could go out and spend $10,000 on a beautiful leather-bound will drafted by the best law firm in town, and I could date it August the 1st, and that's in force, and it tells everybody what I want to happen. If I happen to change my mind a week later, say August 15th, and I've changed the terms of that will, I can write it on a napkin. So say I'm at some place and my brother's around, and I say, you know what, I'm going to give you my baseball cards instead of leave them to my cousin. And I sign it, and he signs it, and somebody witnesses it, and it's got a date on it. That napkin is called a holographic will. Generally, those are the requirements. It usually has to be witnessed, signed by both parties, and dated. That napkin takes precedent over that $10,000 leather-bound will. So holographic will, you want to look up your holographic wills. Most times that happens in situations where you have a will that was drafted a long time ago, things have changed, and you just write something out. Keep in mind that no matter what you put in your will, whatever you write down, it could be anything. That will can and may be probated. Probate can be a little thing or it can be a huge thing. I can tell you for example, in my situation, my mom passed away a little over 3 years ago, and she only had one asset that was not in any type of trust or otherwise, and that asset was her home. We were able to settle everything in the estate, but that house took 2 years to probate. 2 years. So try to avoid a will other than your personal items, your jewelry, like I said, your jewelry, your baseball cards, things that that not only will they be, going to the right person, but there won't be a fight in the family over those assets. So that's basically what a will is. A will can be contested by any interested party, meaning it could be a family member, it could be anybody. Keep in mind also when your client or someone in your family passes, there's generally requirements that all potential creditors are notified, so anybody can come in and fight a will. The most important line on this slide is the bottom. Assets with named beneficiaries, or if they're jointly owned with rights of survivorship, generally how we own most marital assets, those assets avoid probate. They pass by contract. They pass by will. They don't pass by the will. They pass by beneficiary designation or otherwise. So try to avoid anything that's specifically in a will, if possible. The next step beyond the will and your basic estate plan is your power of attorney. These are huge. Every state, most states, bar associations, if you look up whatever state you're in, bar association, they will have pre-approved varieties or variations of powers of attorney. There's 2 types of powers. One is the durable power of attorney, and it generally designates contracts, financial decisions that one person makes on behalf of the other. The second type is the medical directive or the medical power of attorney, and that's where you're able to make medical decisions for someone. By far the best way to draft these documents, if you're not an attorney, but if I were an attorney in a specific case, I always make these documents effective immediately. Not that someone's going to actually jump in and make a decision, but what typically happens if they're not effective immediately is someone gets sick or real sick, And at that point, it's tough to then go back in and have that person deemed, unable to make decisions. You're generally going to have a court involved, and it takes that type of a decision to really have those powers of attorney effective. So, very important, in my opinion, as an attorney, although I don't practice anymore, to make those powers effective immediately. On both the durable power and the medical directive, it's imperative that a client, or in case if it happens to be your situation, make sure that your bank, your investment company, your doctor, you want to make sure that those professionals will honor the document that you have. It might take them, they may have to send it to somebody to verify everything's good, but you want to make sure that those are approved so that if something does happen to you or a loved one, that you already know that it'll work. The bank has to look at it. The investment group has to look at it. Definitely all the doctors. So just kind of trying to make things a little easier. Revocable trusts are a way of avoiding probate. So a revocable, this is not irrevocable. We're going to talk about irrevocable in a minute, but a revocable trust is important because it designates who the beneficiary is, and whatever's in that revocable trust avoids probate. So it allows the transfer of assets to named beneficiary. There's no probate cost. Like I said, it took 2 years to probate one asset in my mom's scenario, and it was thousands of dollars of legal fees to get that thing done. Now, the revocable trust names the beneficiaries just as your will did, except this avoids probate. So a huge opportunity. Most revocable trusts, upon the death of the person who set it up, will become irrevocable, so nobody can go in there and change it around. Now, the biggest point on this, the last 2 bullet points are huge. Number one, if I have a revocable trust, that's great. It might cost me a couple $1,000s for a revocable trust. I actually have to change the title on assets to the name of the trust for the trust to be effective. So if I have some assets and I put together a nice revocable trust, but I don't indicate in that trust what assets are now owned by that trust, effectively, I wasted my money. Last but not least, the revocable trust, which is part of the common estate plan, the revocable trust does avoid probate, but any asset that's in that revocable trust is still in my estate. It doesn't remove assets from an estate because it's revocable. I can make changes, which basically keeps it in my estate. So your high-level basic estate plan is going to involve a will of some sort. It's going to involve 2 types of powers of attorney, and most of them will also involve a revocable trust. All right, now we get a little bit deeper, or a lot deeper. For those folks who, again, at this point, the definition of high net worth changes depending on what the tax laws look like. But at a higher level of even going into the details, the estate tax system and the gift tax system are unified. And what that means is, say I have a $10 million estate, or I have, let's say I have $10 million net worth. That net worth is right now, I'll tell you the numbers here in a minute, but right now that $10 million net worth is not subject to estate tax. Now, if it grows, it could be subject to estate tax, but there's 2 ways of taking care of locking in the current tax laws when it comes to gifting and estates. I can either die with something and my net worth be less than the maximum amount allowed, or I can gift it. And as we move forward in these slides, gifting is the magic tool, because when I gift something, if I gift something today to my kids or to family members or friends, or a trust for the benefit of those folks, that asset is removed from my estate along with all appreciation on that asset. So the most, and we'll get into some details on what's going to happen here potentially in a year or 2. But right now, by making a gift, I lock in the current estate and gift laws. So right now, as we're standing here today, most of you are aware, most folks and most clients are aware that they can give away a certain amount of money every year to anybody that they please. And right now, that number is $18,000 per recipient. So the second from last bullet point, I'm going to go backwards here. Second from last bullet point is that I can give everybody who tuned in today $18,000. Now my spouse can join me in a gift, and now we've got $36,000 per recipient. So technically I could write a check today for $36,000 to everybody who's tuned in, and I won't pay a dime of gift tax, and neither will you. Now, if Jody gets $18,001, then, and that's specifically from me, that extra $1 starts to chew away at what's called my lifetime gift exemption. That lifetime gift exemption right now is $13.61 million per individual who's making the gift. So what that allows is, if you're a married couple, you can go just over $27 million of transfers, permanent transfers of assets to friends, families. Generally, it's going to be to a trust for the benefit of those people. But I can remove $27 million from my estate today, plus all appreciation, by just using my current lifetime gift exemption. It's as high as it's ever been. And this is the number that I'm going to highlight here in a minute and tell you what may happen in the near future. Bottom line is that the gift tax law includes both the annual gifting, which right now is $18,000. It usually goes up by cost of living. So depending on what the cost of living is this year, it might be a little higher next year. And again, like I said before, spouses can join to make that a $36,000 gift per recipient. Very important is that the estate tax law, meaning that, the law that affects you when you die, is the law in effect when you die. So the estate tax law applies to you or to your client in the year of their death, but the gift tax law applies in the year of the gift rather than death. So basically, by making a gift, I lock in the current estate laws. A completed gift, meaning I have no strings attached, a completed gift removes the asset and all appreciation. Because there was there's going to be a change in estate tax laws soon. Back in 2019, there was an IRS regulation that came out, and what it said was that if you make a completed gift and effectively lock in the current gifting amount, that's the 13.6 per person, you've locked it in. So at the bottom, use it or lose it. That's effectively where we are right now, and I'm going to go a little bit off target here in a second. But use it or lose it. If I make a gift today, say I had a very high net worth and I used 13.6 for me, 13.6 for my wife, just over $27 million. Say we transferred $27 million to an irrevocable trust. When we talked about the wills, we talked about revocable trusts. Those assets are in your estate. But if you put together an irrevocable trust, those assets are now removed from your estate. So most folks who have higher net worth, and this, what I generally recommend is take a look through your book of business with your clients, and anybody worth at least $5 million or over that you're aware of, you need to have these conversations. But what's going to happen, that last bullet point is IRS final regulation, Treasury Decision 9884 confirms that the IRS will not claw back assets prior to 2026. The reason it says 2026 on there is because the current estate and gift laws came into play with respect to higher amounts when Donald Trump took office. He doubled the amount of the exemptions of these credits. It had been 5 million and he doubled it to 10 million. It's now 13.6 with cost of living. So it's grown significantly. But that same law technically expires on January 1st, 2026. Now, Trump has indicated currently that if he's reelected, he will extend these tax credits or these exemptions. The current White House had indicated in its 2025 budget that they want the change to be expedited from 2026 to 2025. So let me kind of highlight that right now. What that means is that there is a potential for change depending on who wins the election in November. There's a potential that as of potentially January 1st, 2025, what is now 13.61 million could drop down to, it would probably be either 5 or 6 million, depending on what flows through Congress. This means that you have an opportunity right now to have a general conversation on this subject with your higher net worth clients. If they make a gift, I've already indicated with this Treasury decision that if they make a gift now, they lock in the current credits. That removes the asset plus all appreciation from their estate. So these are really important conversations to have. I can help you in the conversations if needed. Write down something, and this is something that you can reference with respect to general conversations. I want to make sure that everybody understands that a conversation on the estate tax change potential, this cannot be a threat. This is just a general conversation for those clients that this might apply to, that the law could change as its effectiveness as of 1/1/25, rather than wait till the law expires in 2026. What that means is it is literally use it or lose it right now for clients. I've had conversations with clients on the phone on these subjects, and some clients are going to wait until the election results come out before they decide to make a large completed gift. Unfortunately, although that can work from a standpoint of moving money or assets, it's very common. In fact, it will be extremely difficult at the end of this year, especially depending on how the election goes. It may be very difficult to get in touch in front of an attorney who can draft the trust for those gifts. So if you have a client with high net worth, it's very important for them to reach out to an estate attorney or at least a tax attorney to talk about these things and make changes to their current plan. Very important that you initiate that conversation. It's even more important if you have any estate attorney that you're familiar with. Keep that business card handy to refer your clients to. The attorney then knows that you gave them the lead. If you don't, I think it's important to try to make a contact with an attorney locally who you can refer clients to. So long slide, a lot of conversation, but this is a major, major situation. Write down, I said to get something to write with, write down 2025 Green Book. 2025 Green Book. 2025 Green Book is the Green Book is referencing the annual let's say pitch that each president makes to Congress, indicating what their intentions are in the following year. So Joe Biden put together a 2025 Green Book back at the end of March of this year, and if he, of course, he won't be reelected, but most likely there's been no indication of change in that 2025 budget from the standpoint of the Harris team. So there is a significant chance that if Harris is elected, that the changes would be at least attempt to make them retroactive to January 1st, 2025. Again, use it or lose it on gifting. Lock it in. So this slide just kind of goes through what I just talked about, how everything supposedly changed is going to change 1/1/26, but maybe expedited to 2025. By the way, that Green Book has a lot more stuff in it. There's another very significant situation involving capital gains. Since Biden came in, he and Congress behind him have been working diligently to double the capital gains tax rate from 20 now. The maximum right now is 20% long-term capital gains. In their notes and in their situation and in several bills that came out as soon as Biden took office, it was to drop, instead of 2026, it was to drop immediately from the estate tax rate was going to drop, but the capital gains was going to double to 40%. So a lot of conversations involving that. You don't want to use this as a threat, but if you've got a client that's got high net worth assets and you want to make sure that they've locked in the current lower capital gains rate, I've had conversations with clients that want to avoid capital gains at all costs, but when we've had this conversation, they may have sold off assets, especially real estate, appreciated real estate. Some have actually sold off businesses that they felt that they would be looking at selling off within a couple of years. They're selling them off this year to pay 20% max versus 40% max. So again, not a threat because there's a lot of strings attached to these changes. Check out that 2025 Green Book, read through the capital gains changes. Some of it is going to scare you. So in estate planning, we've got, I've already referenced revocable trust. I've talked about irrevocable trusts. Trusts are important because if I want to make a large gift to somebody in my family, I don't want them to abuse the gift, or I want to make sure that, I've got fingers from the grave. I will put different trusts together to help my estate and basically their estate. On this slide, I talk about family and marital trusts. Now, family and marital trusts, this is like the basic estate plan for higher net worth individuals. Many of your clients, if we're talking about $5 million estate, if clients have had trust documents or estate plan documents drafted years ago, it could be I'd say 5-6 years ago or older, they need to be updated for a number of reasons. One, they need to be updated because things may have changed. And whether it's by sell agreements in business, wills, trusts, whatever, it's really important that periodically the client review their documents to make sure nothing has changed. I can't believe how frequently things have changed. Nobody says anything, and then either something happens that triggers that document, and it's wrong, or the client looks back and does take the time to review and can't believe what would have happened if they hadn't reviewed it. So, as a financial professional, advise your clients to review their wills, their trusts, documents, and it's a good time right now, since we're talking about year-end potential changes, to have that conversation, review documents. So the older estate plans will have a family and marital trust because back in the time when those trusts were drafted, you needed to identify the direction of the transfer. One would be to your spouse. One would be one group of transfers would be to family, friends, or etc. At this point, we have what's called portability. What this means is that most of those family and marital trusts are no longer necessary. That doesn't mean they're not effective. If you've got a trust if you've got a trust scenario, estate plan that indicates both family and marital trusts, those rule, but you don't need them anymore for the newer estate plans. Portability means that if I pass away and I haven't used any of my 13.6 million, my wife gets that 13.6 million. So she now has almost $27 million of exemptions in her own estate. The conversation is, okay, I pass away, so my assets go to my spouse. So since she now has more assets that are just in her name than she may have had before, the portability protects her from a larger estate tax. It's very common with respect to estate planning that a life insurance policy be available to create income tax-free death benefit. So clearly, say I pass away and my estate tax is $1 million. Say I'm not married, but I have kids. So now my kids have the problem. They got to pay estate taxes on my life within 9 months of my death. They may have to sell off assets, liquidate assets. So what we do is we try to put a life insurance policy in place. It would be on my life, since I'm the person who effectively is going to die here. So bottom line is a life insurance policy on my life that creates liquidity. Now keep in mind, death benefit from life policy is tax-free. So no income tax due. That liquidity avoids my kids from having to sell off my business or any other assets in order to pay the estate tax within 9 months. So life insurance is a key piece within the estate planning situation, creating liquidity. I got to make sure that I don't own that life insurance policy, because if I own a life insurance policy, or I can control a life insurance policy, that effectively brings that death benefit. In my example, it was $1 million. $1 million death benefit comes back to my estate. Even though there's liquidity, that $1 million is also in the estate, which can exacerbate the estate tax situation. There are trusts that are generally designed to hold life insurance policies. They're called irrevocable life insurance trusts, or ILIT for short. You don't specifically need an ILIT. Any irrevocable trust can hold a life insurance policy. So when you're looking at a client scenario that it appears that estate taxes can be an issue, a life insurance policy is definitely something that they're going to be looking at, hopefully in a trust. Because if I own my own policy, it's in my trust. That trust will give the beneficiaries, say it's my kids, it'll give them the right to receive the money. So if I have $1 million life insurance policy in the life insurance trust, and I pay $100,000 a year, let's say, or even $20,000 a year for premium, the $20,000 is considered a gift to the trust or a gift to my kids. They have to have notice that they do have the ability to take some of that $20,000 out, since they're beneficiaries of the trust. That right to take money out is called a CRUMME, CRUMMEY, a CRUMME power. what happens typically is clients say, why do I want to give my kids the ability to get the premium out, the gift in, because then there's no premium paid. Unfortunately, that has happened where the kids or the beneficiaries of the trust take that money and run away. And then generally what happens the next time Thanksgiving comes around is mom or dad indicate to the kids that since they took the last gift, they're not going to get anything other than that. So bottom line is ways of controlling it from the grave or prior to the grave. But a life insurance policy in a trust is a huge way of creating liquidity. It is a general conversation that should be had with most clients that have, even like I said, even $5 million in net worth. You want to just make sure that there is that liquidity. Again, you got to remind the clients, if they own a life insurance policy on their life, then that death benefit can be subject to estate tax. Many clients are holding on to appreciated assets. It could be stocks and bonds. It could be real estate. It could even be a business. And the conversation that I used to have, aside from this year, I'd say this year it's been different. But in prior years, everybody hates paying capital gains tax. They just don't want to pay tax at all. I paid tax on my initial investment because it was after-tax money. That money grew. Why should I pay capital gains tax? Well, you pay capital gains tax because of the capital gain. Now, right now, it's going to be a little different. But historically, a charitable remainder trust has been a very popular tool to avoid the long-term capital gain. The way it works is, I've got a piece of real estate. I know it's worth $5 million. I only spent $1 million on it. I got a $4 million capital gain. I don't want to pay long-term capital gains on $4 million. Capital gain could vary between 0% and 20%. But I just don't want to pay 20% long-term capital gain. So I put together a charitable remainder trust. I go to an attorney. Usually costs a couple $1,000s to draft a charitable remainder trust. And the attorney indicates in there, or in that trust, that this charitable remainder trust is going to last whatever I tell them. It could be 10 years. It could be lifetime. And during that 10 years or lifetime, 15 years, whatever, I retain income. I'm retaining income. So charitable remainder trust. What the remainder is what's left in that trust when my income interest or when that trust ends. So say I do a 10-year charitable remainder trust, I retain income that I indicate in my trust. It's usually 5%. And after 10 years, whatever's left goes to the charity that I indicate. It's a great way of, number one, avoiding capital gains tax, retaining some income, and also obviously, rewarding or benefiting a charity. To a certain extent, it's a little bit of a legacy that I'm creating with that gift to charity. So I'm happy. I've put my assets in a charitable remainder trust. The charity's happy. They've put assets in a charitable remainder trust. The IRS, it's kind of a wash to the IRS. They lost tax on that money, but that doesn't mean that they've lost anything from a tax standpoint generically. The party who's not happy is my kids, because my kids were going to inherit that asset. Now they don't get it. So this is where we look for a life insurance policy, either owned by the kids or owned by a trust for the kids, to replace that asset. So again, you're looking at a client that's got some greatly appreciated assets. They want to take the gains based on the current market, but they don't want to pay capital gains. A charitable remainder trust may be a solution for that client. Because of the potential for a doubling of capital gains tax, way fewer conversations on charitable remainder trusts this year, because folks realize that there could be a doubling of the capital gains tax next year, again, depending on the November election. So why not just pay your capital gains at 20% and be done with it? Another type of trust that is very common, aside from a charitable remainder trust, is called a grantor retained annuity trust, or a GRAT. This is another way of retaining income from an asset that you place in it. At the end of the term of this GRAT, instead of going to charity like in a charitable remainder trust, it goes to family usually. So it does benefit family. It does allow income to me if I draft this trust. The downside to a GRAT is, I'm just giving you highlights of these types of trusts. The downside of a GRAT is that if I die during the term of my trust, my GRAT, because I had retained an income stream, the assets that are in that trust come back to my estate. I know I'm going a little fast. I know this stuff is complicated, which is why you have my contact information. But the bottom line is right now, a GRAT is an opportunity like the CRT to basically avoid a general capital gain. It does allow gifting anything I put in that trust to the GRAT to my kids. That is deemed a gift, so I am using some of my current lifetime gift exemption at 13.6 million. So it can be a good tool. Again, it's just a general conversation, and in a normal sense, the value of a GRAT is higher than it is typically because of the higher interest rates now. So many attorneys are using GRATs. You just have to make sure, or they have to make sure the client is aware that if they die during the term of that GRAT, they are going to have that asset in their estate. So again, the GRAT, even the CRT, it does remove assets from the estate. You generally do also lock in, because of the gifting opportunities on the GRAT, you lock in some of your lifetime gift exemption. Sometimes attorneys will draft a series of GRATs, like 5-year, 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 so that each 5-year period becomes its own risk. But at the end of those 5 years, then the kids would get, if I draft 3 5-year GRATs, at the end of the first 5 years, whatever's in that trust goes to my kids. That's out of the estate. Second 5 years, I'm still alive. Whatever's left in that GRAT goes to my kids. The third 5-year term, I pass away. Those assets are in my estate. So these are just conversations that you don't necessarily go into detail on these, but attorneys may recommend a GRAT. They may recommend a charitable remainder trust. There are other types of trusts that can be commonly used in an estate plan. Here's one that is generally used, and this is survivorship standby trusts are kind of bizarre right now. They don't get much activity just because of some of the other opportunities that have been developed. But the last slide on this, or the last bullet point on this slide, you're going to hear about something called a spousal lifetime access trust. The value of a spousal lifetime access trust is that I can remove assets from my estate and from my wife's estate in a spousal lifetime access trust, and still allow my spouse to benefit from assets based on certain measurable needs. There are magic words. Typically, the way this works is I'd put a slat together. My attorney would put a slat together, and it would, I can't touch it, but my spouse can receive income after my death and the magic words usually used are health, education, welfare, and maintenance. Basically, measurable standards that whoever my trustee is can look to determine how much is available to my surviving spouse. But because there's a limit on it, and because if I've got an independent trustee, the assets in the trust are not in her estate. So I can actually allow for support of my widow without having her estate, grown and subject to estate tax dramatically. So these are types of trusts that we're going to talk about. Now, I want to make sure that everybody understands that is the end of the basic estate planning conversation. The basic estate plan, your wills, your powers of attorney, trusts, from everything from a revocable trust to an irrevocable trust to charitable remainder trusts, etc. This can be a very difficult conversation for you to have with your clients, especially if you don't have a deep background. My rules of engagement when it comes to this stuff is you and I have a conversation. We talk about the client's scenario, and then we can go from there. I can help you with a conversation. However, it gets a little better. What I put together a few years ago was a series of slides, and these are going to go to Jody, so she has a chance to take a look at these. I put together a series of slides that effectively highlights what we've already seen in this presentation. The first 23 slides so far are the basics and a little bit more advanced on estate planning. So that you don't have to go deep on this, I put together a slide presentation. I call it Pass It On, because you're passing on assets. And this is a slide presentation it's only 12 slides. It's very simplistic. It hits the highlights of the stuff that I've talked about, but doesn't go too deep. So basically you can have a tool at your disposal that clients can have access to. Again, what I generally recommend is if you and I talk before the presentation, you can do the presentation, you walk through it, you take notes. From that point, you and I talk about a specific scenario, and we get on the client call with that client. But Pass It On is a client-facing presentation, 12 slides, very simplistic version of what we just talked through. It's less than half of the slides that we talked about. This is going to be available to you. However, before we do that, I'm going to send this to Jody for her to run through your own version of compliance to make sure that it's good for you. Jody, that's about it. I've got, I can run through these slides just to kind of walk everybody through this. So I'll do that real quickly here. But in a nutshell, it starts off with why plan. This goes through the basic stuff on why there is an estate tax. This slide on the federal estate tax goes through the details that we just talked about. Now, keep in mind, on the left part of the slide, it references a $13.61 million exemption. Keep in mind that as of January 1st, depending on the cost of living and depending on who wins the election, that can go up by cost of living or it can go down based on legislation. So that 13.6 is current. Again, it does literally lead to a conversation on use it or lose it with respect to gifting. If you do make a gift, if your clients make a large gift, this just talks about the annual gift of 18. But if they make a larger gift, interesting that, if they do make a larger gift, not only is the asset out of the estate, but they have locked in the current tax laws. So that's a big opportunity for clients. So the client removes assets from their estate, and the benefit to you as the financial professional is now you've got another generation of clients who've received assets because the clients took your advice and made a large gift, either in trust or directly. This slide goes through the very high levels of what clients might be aware of, their marital trust, their credit shelter trust. For the higher net worth, really higher net worth, generation skipping trusts are the most popular. This is a trust that can go on for multiple generations, moving assets to the multiple generations, still allowing for income as needed from the trust to the current beneficiaries. Other common tools, this goes through the basics. Again, the very basics of a will, talks about the powers of attorney, both financial and medical. Paying estate tax, this is generally the slide that starts to get some things moving. It talks about what the estate tax is, how to pay the estate tax. We do reference life insurance because life insurance would be a tax-free income version of liquidity that may avoid the quick sale of assets. So, at that point, we wrap up. This is you giving this presentation. You don't have to have all the answers. You let them know that that I am part of your team of experts and I can help the client. I will not be their attorney, but even though I'm not their attorney, because they work with you, they get guidance. They get guidance from our conversations. And that's it. So this, again, will go to, I'll send this to Jody and she can walk through this with respect to compliance, and hopefully everything works out from your standpoint. I appreciate everybody tuning in today. It's my pleasure. You've got my contact information. And don't hesitate. If you just want to call about a scenario, a general scenario, don't be worried about it. I'm just there for you, and I am part of your team of experts with respect to client scenarios. So Jody, I'm going to tune out right now. Any thoughts or final questions?
That was great stuff, Alan. I tell you what, I'm kind of in the midst of that in my current life right now with my parents. And so I learned a lot of things today. I was taking down notes. So we've got some extra time. Does anybody out there have any questions for Alan before we sign off? Okay, I'm going to take that as a no questions. You've got all of Alan's information, and like he said, he's going to be sending some stuff our way. We're going to make sure that it's compliant, and we can forward that to you. This webinar was being recorded, so we have that as well. So we, I think we'll call it a day. Alan, thank you very much for all that information. That was good stuff. And
thank you.
If there's no questions, we will sign off.
All right. Take care, everyone.
All right. Thank you. Bye-bye.
Bye now.